court is going to proceed first with Ms. Smith. Just one moment, please. The court finds that prison is consistent with the purpose of revised code section 2929.11. As to count 1, aggravated murder, this court sentences Ms. Smith to a life sentence without being eligible for parole until serving 30 plus 3 years on the 3-year firearm specification. So the first time Ms. Smith will be eligible for parole will be after serving 33 years, and the institution can keep Ms. Smith for life. As it relates to count 17, conspiracy in violation of 2923.01A2, that is the felony of the second degree, that is the qualifying offense that the court was referring to earlier. The court sentences the defendant to a minimum of 8 years and a maximum of 12 years. Count 17 to run concurrently to count 1. Strike that. Count 17 shall run consecutively to count 1. And the court makes those consecutive findings pursuant to Ohio Revised Code section 2929.14C4B. The court finds that the consecutive service is necessary to protect the public from future crime or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. And the court also finds, again, pursuant to 2929.14C4B, as in boy, at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as parts of any of the courses of conduct adequately reflects the seriousness of the offender's conduct. And the court makes that finding. The court sat through, as indicated by both the prosecutor and counsel for the defendants in this matter, 3 separate trials and heard all of the evidence. Ms. Pointer was kidnapped, tortured, taped. She had a gun placed down her throat, beaten, and then left after being shot in an abandoned house in East Philly. For those reasons, the court finds that consecutive sentences are appropriate for Ms. Smith. Moving on to strike that. Moving on to Mr. Bryant. The state concedes, as indicated earlier, that counts 1, 2, 3, 4, 5, and 12. Strike that. Counts 1, 2, 3, 4, 5, and 6 and 12 merge for the purposes of sentencing. The state, in their sentencing memorandum, elects to proceed on count 1, aggravated murder. The court finds that prison is consistent with the purpose of Ohio Revised Code section 2929.11. The court imposes a prison sentence at Bryant Correctional Institution of life without the possibility of parole plus 3 years as to count 1. Further, the state concedes that counts 7, 8, and 9, counts 7, 8, 9, and 16 merged, state elects count 9, kidnapping, in violation of 2905.01A3. The court again finds that prison is consistent with the purpose of revised code section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution of, as count 9 is a qualifying offense as it relates to Reagan Stokes. The court sentences the defendant to 11 to 16 and a half years on count 9, plus the 3-year firearm specification. 3-year firearm specification must by law be served prior to and consecutive to the underlying sentence of 11 to 16 and a half years. The court further finds that count 9 shall be served consecutively to count 1 pursuant to Ohio Revised Code Section 29.14C4B, which is exactly what the court just read previously, and the court makes the same findings. The facts in this matter are completely horrific. Ms. Pointer was tortured and ultimately shot to death and left in an abandoned house. The court finds that pursuant to 2929.14C4B that consecutive sentences are appropriate for Mr. Bryant. Moving on to Mr. Shomo. Again, per the sentencing memorandum filed by the state of Ohio, the state concedes that counts 1, 2, 3, 4, 5, 6, and 12 merge for the purposes of sentencing. The state has elected, again, pursuant to their sentencing memorandum, to proceed to sentencing on count 1, aggravated murder. The court finds that a prison sentence is consistent with the purpose of revised code section 2929.11. The court imposes a prison sentence at Lorraine Correctional Institution as to count 1, life in prison without the possibility of parole. Mr. Shomo was found not guilty of the gun specifications as it relates to count 1. Further, the state concedes again in their sentencing memorandum that counts 7, 9, and 18 emerge for the purposes of sentencing. The state has elected to proceed on count 9, which is also stated here in court by Mr. Filiatro. The court finds that prison is consistent with the purpose of Ohio Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution as to count 9 for a period of 11 to 16 and a half years, plus the 3-year firearm specification that must be served prior to and consecutive to the underlying sentence on count 9, which is the 11 to 16 and a half years. Next, as it relates to count 10. The court finds that prison is consistent with the purpose of revised code section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution of 11 years. As it relates to the 3-year firearm specification in count 10, that 3-year firearm specification will run concurrently to the firearm specification in count 11. Moving on to count 11, the court finds that a prison sentence is consistent with the purpose of, again, Ohio Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution of 11 to, strike that. The court imposes a prison sentence at the Lorraine Correctional Institution of 11 years as it relates to count 11 in addition to the 3-year gun specification, which again must be served prior to and consecutive to the underlying sentence of 11 years on count 11. Further, count 11 shall run consecutively to count 9, in addition to the 3-year firearm specification in count 9. The court again finds that consecutive sentences are appropriate, again, for Mr. Shomo pursuant to 2929.14 C4B and also C. Again, the reasons this court has indicated as it relates to 2929.14 C4B apply to Mr. Shomo. I can't emphasize enough the torture that Ms. Pointer experienced by these individuals in addition to others. So those same findings apply as it relates to Mr. Shomo pursuant to 2929.14 C4B. As it relates to 2929.14 C4C, the court also finds that consecutive sentences are necessary as the offender, Mr. Shomo, has a prior conviction of robbery, which is an offense of violence. Just one moment, please. Moving on to count 20, Mr. Shomo. The court finds that prison is consistent with the purpose of Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution as to count 20 of 3 years. There were no firearm specifications attached to count 20. Just one moment, please. Next, this court must advise the defendants as it relates to post-release control. For the record, Ms. Smith.
We don't think post-release control is appropriate considering she's going to be facing parole. We don't think it applies.
Thank you, Mr. Schleckett. Mr. Pilato, do you have a position on that?
Given that counts 1 and 17 were to be run consecutive, I think the advisement for PRC is valuable today, so I would request the court advise it. Whether it's imposed or not, may or not be the case at that time, but because it may be, I think the advisement's appropriate.
Thank you, Mr. Pilato, and thank you, Mr. Schleckett. I am going to advise each defendant as to post-release control on the counts that it applies in an abundance of caution. So as it relates, Ms. Smith, to your post-release control. Ms. Smith, that applies to count 17, which post-release control carries with it a mandatory minimum of 18 months up to 3 years upon your release. It is mandatory. Do you understand?
Yes, Your Honor.
And Mr. Bryant and Mr. Shomo. Post-release control as relates to your cases is mandatory. Should you be released and placed on post-release control, it would be a mandatory minimum term of 2 to 5 years on post-release control. Do you understand that, Mr. Bryant?
Yes.
Do you understand that, Mr. Shomo?
Yes.
Thank you.